seated, please. Good morning. We have team 762 petitioners and team 621 the respondents. Could I ask all counsel, starting with petitioners, just to introduce yourselves so we know your names and how they're pronounced, starting with both counsels, petitioner, the person who's going to argue first, and then second, and we'll do the same thing with respondents.
Dandee Cabanay on issue 1 on behalf of the petitioner, Your Honor.
Thank you. Good morning, Tiffani, Skroch, issue 2 on behalf of the petitioner.
Good morning, Your Honors. My name is Kyung, Liu-Katz, arguing on behalf of the respondent, issue number 1.
Good morning, Your Honors. I'm Shakuan. I will be arguing responding to issue 2.
Thank you, everybody. You may be seated. If we are ready to begin, let me see where we got bailiffs over here. Okay, great. Well, if petitioners are ready, you may begin.
Mr. Chief Justice, and may it please the Court. My name is Dandee Cabanay, and along with my co-counsel, Tiffani Skroch, we represent the petitioner in today's case, Professor Jonah Smith. Today, I will demonstrate for the Court why the Pickering balancing approach should apply to a professor's in-class instruction, such as Professor Smith's use of the Socratic method in his philosophy of law course. My co-counsel today will argue that a public university may not compel its professors to speak contrary to their strongly held ideological beliefs in the classroom. The issue before the Court today presents yet another opportunity to reaffirm the landmark decision of Tinker v. Des Moines and its central tenet, that teachers and students do not shed their constitutional rights at the schoolhouse gates. The 13th Circuit below applied Garcetti, which holds that if a public employee speaks pursuant to her official duties, that speech is government speech and is categorically excluded from the First Amendment's protection. This decision turns Tinker into a lie by forcing Professor Smith to shed his constitutional rights at the classroom door. Thus, this Court should reverse the 13th Circuit's opinion for 3 key reasons. First, under this Court's jurisprudence, a professor has an individual interest in academic freedom. Second, the Garcetti Court expressly declined to extend its rule to a professor's in-class instruction. And finally, the Pickering balancing approach properly weighs and balances the competing interest in this context.
Mr. Cabanay, is there anything that a college could require a professor to teach?
Yes, Your Honor, it would go to the course and material of that class, and it would depend on the scope and what those things were, Your Honor.
So why doesn't why doesn't that defeat your compelled speech argument?
It doesn't, Your Honor, it doesn't defeat the compelled speech argument because WCC is attempting to have Professor Smith convey an ideological message, which my co-counsel will get into more detail, but the government cannot compel someone, an individual, to convey an ideological message, as my co-counsel will get into. My issue today will focus more on the retaliation claim with the philosophy of law course, where WCC instructed Professor Smith not to use the Professor Sanders and Mr. Michael's example. And it is our position that the government could not do that because that is infringing on his academic freedom. Which brings us to, under this Court's jurisprudence, a professor has an individual interest in academic freedom.
Could I why should I understand that the Court in Garcetti, in fending off just the suitor's dissent, said, well, we're really not deciding the professor issue. But I'm having trouble thinking of a principled reason why the issue that we faced in Garcetti, which involved corruption essentially in a district attorney's office, is somehow deserving of less constitutional protection than what your client did. That seems odd.
Well, Your Honor, the difference here is that academic freedom in the classroom for a professor. And this Court has stated in 1957, going back to a landmark decision in academic freedom in Sweezy v. New Hampshire, that a public university, if they were free to impose a straitjacket on the intellectual leaders of the classroom, like the professors, that would imperil the future of our education.
Suppose a college offers a course in evolutionary biology, and the professor is a creationist and wants to teach creation science, does the school have to let him do that?
Possibly not, Your Honor, and most likely not, because under the Pickering balancing approach, the university would have a very strong interest in ensuring the course content is being taught appropriately and according to science and approved facts. So in that instance, in that hypothetical, if it was a biology class or a evolutionary class, as you put it, Your Honor, the university would have a very strong interest in making sure those concepts were taught, and that would be allowed to happen under the Pickering balancing approach.
Why do we even get to the Pickering test in that concept? This is the government as employer, not the government as a non-employer. So why do we even get to Pickering when, in Garcetti we said if speech is done in the course of official duties, it's government speech. He's getting paid to teach from the classroom. What he does on his own time, or even on campus outside of class, that could be different. But why can't he be disciplined for comments that he makes in the course of his paid duties?
Well, Your Honor, 2 points. As the Associate Justice pointed out, Garcetti, we did not expressly extend this rule to professors in class instruction, and that can be seen because of the academic freedom that's necessary to cultivate the marketplace of ideas in that classroom. And this court has historically stated from Sweezy and then 10 years later in Keishan v. Board of Regents that a professor must be free in the classroom to cultivate the marketplace of ideas for students to engage in the diverse showing of viewpoints without fear of an authoritarian selection.
So is your position that Pickering applies to really both issues in this case?
Well, Your Honor, it applies to the professor's retaliation claim, and my co-counsel will go into how it would or may not apply to the compelled speech issue, focusing more on the government speech doctrine.
Well, I'm having trouble with that because it seems to me that the rule would have to be the same. Go ahead.
The difference there, Your Honor, is here with the retaliation claim in Issue 1, we have the government restricting speech. It's a restriction. In Issue 2, we have the government compelling someone to speak, forcing. So that's where the difference is. The government saying no, not to speak in this issue. And on the second issue, my co-counsel's issue, the government is compelling Professor Smith to speak, which is why the two different doctrines are being used differently.
Do you think that there's any analogy here to the public forum analysis that we apply in a different area of First Amendment law? In a non-public forum, the government can basically dictate what happens. It's kind of akin to the government speech idea. In a public forum where people are invited to express their views, restrictions on speech are subject to strict scrutiny. It seems like there's an analogy between that and what we have here, where you might have an upper level class where academic freedom is encouraged, but then there might be some intro level courses where the state has a strong interest in specifying what exactly is taught. Do you think there's an analogy, a proper analogy to the public forum doctrine?
Well, Your Honor, there may be an analogy there, and I can see where the court's trying to go with that analogy, but the difference would be that in Issue 2, there is a government ideology that is trying to be compelled by an individual who does not agree with that specific government ideology.
Isn't that always true in government compelled speech cases?
Well, Your Honor, it may be true, but the difference here is that the government cannot use a professor or an individual to compel that ideology when it is a strongly held disagreement, as my co-counsel will touch upon on Issue 2.
I have a different question. Your client's comments caused disruption in the class. As I read the record, students became upset. He called upon a visibly upset student. And can't that conduct that causes friction in the class be disciplined? I mean, in other words, what's expressive about harassing a student and who you see as visibly upset and forcing them to take a position that they're upset by? And why can't that be disciplined?
Well, Your Honor, under the Pickering balancing approach, a professor could be disciplined, but the key is that the professor would have the ability to share his side of the story with a court of law, to have his bite at the apple. Under the Garcetti categorical rule, his First Amendment interest in academic freedom is categorically extinguished.
Counsel, let me ask you, if we move away from a categorical rule as you're proposing, let's pretend we're at a trial court and your man is trying to get an injunction to stop the university from conducting or having him conduct the kind of dialogue he wants to have with students. Give me an example of the kind of arguments that would go into a balancing test, and how does a court avoid a totally subjective resolution of those elements?
Yes, Your Honor, and this kind of goes back to the example we were having earlier today with the creationism and the evolution hypothetical. And one of those lines that a trial court could use would be the scope of the content of the course.
Well, put it in the context of this case. The case about evolution might be an easier example. Let's talk about just a dialogue between students that gets rambunctious.
Yes, Your Honor. As page 5 of the record shows, Professor Smith was teaching a philosophy of law course, and the specific topic of the day was the ethical representation for attorneys. And specifically, Professor Smith was using an accessible example for his students to engage in this marketplace, to see the ideas and the constitutional importance and right of defense in a criminal trial.
So what's an argument on the other side?
The argument for the respondents at the trial level would be that it caused a disruption.
All right, so how is that resolved?
It would resolve because the professor has a strong interest in showing and using this example.
So
that the university,
that's the anvil that's thrown on that side of the scales, and the university's interest in decorum doesn't scratch?
Not necessarily, Your Honor. The university has a strong interest in making sure the marketplace of ideas is alive and well as well. And they could argue that there were disruptions both outside the classroom and in the classroom.
I'm sorry to interrupt, but let's say there was a requirement to take attendance in the class. Do you think that would be covered by the First Amendment, and there would be, is that government speech, or does he have an individual right there?
No, Your Honor, that would most likely be closer to administrative speech with an attendance policy, similar to pointing out federally mandated Title IX issues in a syllabus or things of that nature. It's not ideological.
What if a professor is an opponent of immigration, and every time he sees a name in the attendance sheet that he thinks might be suggestive of an immigrant, he says it sort of with a derisive way, would it then lead into something that's expressive and would require a Pickering analysis?
Well, Your Honor, under the Pickering balancing approach in academic freedom, that would probably not go towards academic freedom and his protections of in-class instruction, because it's not furthering a discussion or the marketplace of ideas.
Well, but wouldn't you then be having the court then in the Pickering balancing have to weigh in on what has value in the marketplace of ideas versus what doesn't? I mean, it just seems like there is an advantage to a bright line rule ahead of time.
Well, Your Honor, there are advantages of a bright line rule. It's much more efficiently to use at the trial court level. But this court has never stood for the proposition that efficiency alone is a justification, a sole justification for categorically extinguishing any individual's constitutional interest.
Do we have to apply the same rule at the high school level?
No, Your Honor. The Pickering balancing approach is more appropriate at the public university and college level.
Where does that distinction come from?
That distinction, Your Honor, comes from the more academic freedom that professors are generally granted or generally have.
What about AP classes in high school?
Those courses, Your Honor, generally have a curriculum that is set by the school board and the school district at the high school level. That does not occur at the...
So you would say, like Garcetti does apply at the high school level?
Yes, Your Honor, but there are differences here because of the academic freedom this court has consistently held. And to conclude, Your Honors, the Garcetti rule categorically extinguishes professors from having their constitutional interest in academic freedom vindicated before a court of law and a jury of their peers. It prevents them from having a bite at the apple. And the Garcetti rule allows the government to have complete control over what a professor can say in the classroom. Thank you.
Thank you.
Chief Justice, and may it please the court. As my co-counsel mentioned, my name is Tiffani Skroch, and I represent Professor Smith on the compelled speech issue in this case. When WCC required Professor Smith to speak during the New Student Experience program, the college violated the First Amendment for two key reasons. First, Professor Smith was required to deliver ideological messages with which he deeply disagrees. And second, the government speech doctrine does not cover compelled ideological messages of professors.
Counsel, I'll go back to my hypothetical about a college that has a course in evolutionary biology and has a specific curriculum for that, but the professor wants to teach creation science and says, I don't have to teach this ideological agenda you have, school. How does your analysis work in that situation?
Your Honor, because the professor was hired to teach biology, he would be required to teach biology because it's a matter of content versus viewpoint. When we're looking at teaching biology, this is a curricular decision. The colleges are able to make those decisions.
But didn't the school here make a curricular decision as to what it wanted to teach incoming freshmen?
I apologize, Your Honor.
Didn't the school here make a curricular decision as to what it wanted to teach the incoming freshmen?
Yes, Your Honor. They did make that curricular decision. However, it was how they wanted to teach those students. Here,
I want to follow up on my colleague's question because I don't think I'm following your answer. So, under your view, it is inappropriate for a college to require somebody to say that ownership is a colonial concept, but is permissible to say you must teach the Darwin version of evolution and not creationism?
Your Honor, because the distinction there is what...
Well, just before you explain, so I've got that right. That's your position, right?
Correct.
Other than the fact that it lets you win in this case and avoid a difficult hypothetical, what is the possible justification for that?
Your Honor, because individuals have never been required under our First Amendment to speak ideas that they disagree with. Here, professors...
What if I disagree with Charles Darwin?
Your Honor, take, for example, Hurley, the case where and there was a parade where an LGBTQ organization was not... the court in that case decided that individuals did not have to be required to deliver facts which they would rather avoid. However, when we are looking at an employee here, it's valid for a professor to have to speak scientific facts in a biology class. The distinction is between content and viewpoint.
But doesn't that leave a whole lot of room for, in your case, the professor deciding what he thinks is ideological versus fact-driven?
Your Honor, that goes to what this court clarified in Kennedy versus Bremerton School District last year. The court stated that the government speech question is a practical one that considers both the substance and the circumstances surrounding the message. Here, it's not that the professor has an ideology for disagreeing with a certain fact that he was hired to teach. It's the fact that the message that he's required to deliver is an ideology itself. That's the distinction between your hypothetical. When we're discussing science and facts and discussing teaching creationism in a biology class, they are hired to teach biology. So if they are teaching creationism because they have a deeply held disagreement with biology, the school has a valid reason to require him to teach biology.
This teacher was being hired to teach the NSE class. What's the difference?
The difference, Your Honor, is the statements. It's the messages.
But then I don't see how you distinguish the creation science situation.
Because the message, Your Honor, is not ideological in the...
What's the test for whether it's ideological?
Your Honor, if it's the government's ideology. So if we're looking at, again, content, like science and teaching evolution, that is a content-based choice. If they require the professor...
Doesn't every government speech case involve government ideology?
Yes, Your Honor. However, they do not require individuals to convey those ideologies.
Sure they do. That's why they hire them.
No, Your Honor.
But this was not, I mean, the statement was WCC believes this. It wasn't an affirmative affirmation, I believe this. Why isn't that a good compromise that allows the government employer to get out its preferred message through its employees?
Your Honor, that is a good compromise. However, the court can see on page 9 of the record that WCC categorically denied all approaches that Professor Smith requested, seeking alternatives. He asked to provide a disclaimer. He asked to state these messages in a different way. Instead, he was required to read the government script that says, at WCC, we value.
Counsel, would it be workable for us to adopt a more nuanced rule that said that in a higher level class where academic freedom is permitted, Pickering applies, but in a situation where the school wants to specify the curriculum, it's government speech? Would that distinction work?
No, Your Honor.
Why not?
Under the compelled speech doctrine, control over the message is precisely the issue. When we're requiring individuals to convey government messages that they would rather avoid, we cannot allow them to do so just because they're exercising more control rather than less.
But you lose me there on the going back to the creation science example. Why wouldn't, under your view, why wouldn't that be subject to the freedom of the professor to teach creation science?
Your Honor, because he is able to, say, teach that outside of the classroom. So when he's hired for a science class, he's hired to teach science. So that goes to the content. It doesn't go to...
But this professor was asked to be hired to teach the NSC class. The NSC class. I don't see the difference.
Yes, Your Honor, because it's not the content that's at issue here. It's that he's required to teach the viewpoint as it is his own.
That's true about the creation science example.
No, Your Honor, because there the message he's required to deliver is not an ideological one. That simply, under the scientific view, is... How
do you define ideological?
Your Honor, it is defined by, there's no one simple, straight definition of an ideology. Of course, it would be more of a case-by-case determination.
Well, would the school not assume that its statement about the origins of the land was non-ideological, it was simply a fact statement?
No, Your Honor, because on page 8 of the record, it states that ownership of land itself is a colonial concept. And Professor Smith
is that not factually verifiable or not?
Your Honor, no, because a colonial concept, that is an ideology. It's a theory. Professor Smith, on page 5 of the record, takes a different theory.
Why isn't it enough, though, that on his own time, I mean, he could go back to campus and say, you know, I'm going to get up on my soapbox and tell you why I personally disagree with what I was forced to say in the classroom. Why isn't that enough to reconcile the competing interests here? But we should allow the government employer to have an unmuddied message that it wants to be conveyed during business hours when they're paying him to do so.
Your Honor, because the damage is already done once he's forced to make those statements. Of course, he can speak out against those statements later on, but the whole point of compelled speech is that it invades personal autonomy and implicates much deeper constitutional concerns. So here, of course, he could simply disclaim them later on, but again, he's already damaged. His free speech has already been violated.
Would it have been... he asked, I know, if he could include his own views on his syllabus. Is your position that if the institution had agreed to that, that would have eliminated the First Amendment problem? He could be compelled to say the message in class as long as he had the opportunity to say something else in his syllabus?
Yes, Your Honor. If he was allowed to disclaim it, that would remedy the First Amendment issue here, because simply we recognize that, of course, the employer has more of an interest in requiring their employees to deliver messages.
Why isn't the disclaimer on social media that he can send to, that his students will read 2 seconds after he posts it, why isn't that enough? Why does it have to be in his syllabus?
Your Honor, because there's no guarantee that that message, that later disclaimer, will reach the students that were in that class.
You think it's more likely they'll read the syllabus than an Instagram post from the professor?
Not necessarily, Your Honor. However, we cannot base First Amendment rights on assumptions. Here, Professor Smith was required to make a statement as if it was his own. He did not refuse to teach the course. He did not refuse to teach the content. He simply refused to mislead his students.
Could a state school board require a history class that teaches that property is a colonial concept?
Your Honor, as if it was his, or if it was being taught as his own, no, because if they were teaching that property ownership was a colonial concept, and he was not able to say discuss opposing views, as was happening in the NSC course, then it would likely be violating the First Amendment.
So your rule would apply at the high school level too, which seems contrary to what your co-counsel argued.
I'm sorry, Your Honor?
Sounds like your rule, you would apply your rule at the high school level too.
Oh, I'm sorry, Your Honor. I may have misheard you. In the high school level, there is more of an interest in the state in governing curriculum and what they're required to teach. However, when we are discussing viewpoint, simply here, this is a government speech issue. We're deciding whether or not it's private speech or government speech, not whether or not the professor can be compelled to deliver this message entirely.
If we ruled against you on the first issue, and we said Garcetti's bright line rule applies in that context, would you also lose on the compelled speech issue?
No, Your Honor, because the government speech question has two issues involved. Of course, when a professor is speaking within his job duties, that is one issue, that's Garcetti. However, there's a fundamental principle under the government speech doctrine that the government has to be speaking for itself, and that was recognized in Pleasant Grove City versus Summum. And in Shurtleff versus City of Boston in 2021, the court stated that a primary reason for finding the flags were not government speech was because the city did not clarify that it was speaking for itself. And that's what's happening in this case.
What about I asked your colleague about taking attendance. Do you think a professor could be compelled to take attendance?
Yes, Your Honor.
What if the professor said, well, you know, that would, if I took attendance, that would signal that I agree with the policy that it's important to come to class, when I just think it really is just about the exam, and they can do the reading on their own and spend their time more creatively than coming to class. And I disagree with that policy, and I don't want to be compelled to agree with it. Would that be a valid reason to extend First Amendment protection in that context?
Your Honor, if I could briefly answer your question and then conclude.
Yes.
Your Honor, that would not be a valid reason to not convey that message, to not take attendance, because the message at issue here is the taking attendance. We look at the substance of the message, not just the ideology of the professor. It's both. So if we're requiring a professor to take attendance, that's an administrative task. It's a ministerial speech here that the employer, the college, has an interest in requiring. However, when a professor simply says that he has an ideological disagreement with taking attendance, that alone is not enough. Because here we're looking at whether or not the substance of the message is ideological and whether it's attributable to the person as a message of his own. And here that's precisely what's happening.
All right. You should conclude now.
Okay. Thank you, Your Honor.
Thanks. Proceed.
Thank you, Your Honor. Honorable Chief Justice, Associate Justices, may it please the Court. My name is Kyung Liu-Katz, as stated, and together with my co-counsel, Mr. Shakuan Smith, I represent the respondents, the Westland Community College, and its administrators. I will be arguing issue number 1 regarding the compelled speech, regarding the First Amendment retaliation claim brought by the petitioner, and Mr. Smith will argue the compelled speech claim issue. Your Honors, the respondents respectfully ask this Court to affirm the ruling of the 13th Circuit and hold that the Garcetti analysis applies in this case. This case is about WCC acting not only as a public employer but also an academic institution, exercising its constitutionally recognized autonomy over matters concerning employment administration as well as curricular self-determination. The Garcetti analysis applies in this case for 2 main reasons. First, the so-called academic freedom exception contemplated by the petitioner is misaligned with this court's understanding of academic freedom under the First Amendment jurisprudence. And 2, the rationale of the Garcetti Doctrine explains why a public employer, a community college such as WCC, should be able to control the speech of its instructors.
How far does that control extend? Does it, for example, if the professor had a blog page which was, say, optional for students to use, but it was a way he posted comments and reactions and things like that, would the university's writ extend to that blog page as well? Is that, in effect, does the blog page becomes the university's speech because he's organized it?
Excuse me, Your Honor, did you mention blog page?
Yeah.
Specifically as like a web page that's used? So that would extend towards the curricular speech of the curricular interests of the university. For example, this court in Sweezy, when it issued a concurrence written by Justices Harlan and Frankfurter, stated there are 4 pillars of academic freedom, which was that the university had a right to determine for itself who may teach in the classroom, how it shall be taught, what shall be taught, and who may be admitted to study.
Wait, I'm sorry, Counselor, are you saying that the school could discipline a professor for what he puts on his personal blog page?
Personal blog page? No, Your Honor. I misheard, Your Honor. I'm sorry. I thought it was related to the classroom.
Well, it is. Let's assume it is related to the campus. It's a convenience to the students. If you miss the class, you can go in there and see my notes, for example, and students can comment back and forth.
If that was related to the curricular material that he was teaching pursuant to his employment contract as an instructor, the petitioner would be controlled by the university's curricular interests.
What if it's his personal blog page?
If it was his personal blog page.
I can't believe the university is making me teach this goofy stuff.
Then he would be speaking as a private citizen, and
so that's okay.
Pickering balancing would apply.
What if he links his social media to his WCC webpage?
Then that would be a more complicated matter, and the facts are not in front of us to determine. However, if the purpose and the general understanding is that if it is within the curricular interests of the university or an academic institution, then it would be able to be controlled by the academic institution as long as that was in pursuant to his official duties. And
it seems to me, I mean, we obviously have to decide the question we left open in Garcetti now. But it seems to me that when an institution hires someone like the petitioner to teach a class, necessarily we're investing that person with a ton of discretion about how to do so. That makes speech in the classroom qualitatively different than, say, a motor vehicle administration clerk who's just, greeting someone at the counter. I mean, why should those 2 types of government employees' speech be treated the same?
Because, Your Honor, in this specific case, taking it as an example, the employment contract here specifically stated that Professor Smith will be teaching introductory level classes and philosophy of law classes and nothing else. He wasn't allowed to create curriculum. He wasn't allowed to create a class that he wanted to teach. And he was not even required or allowed to do research on behalf of WCC. So in this specific case, the reason that the WCC hired the petitioner was in order to teach a class that falls squarely within the curricular interests of the
But how to do so, and what on a day-to-day basis, what points to try to emphasize? That's totally, you could hire 20 different people to do that, and they would come up with 20 different ways to do so. Why? How is it that you get to discipline someone for taking an approach that furthers the educational objectives as he sees them?
And that would be because it would go against the proper performance of WCC as a public employer.
Is there any limit to this, to follow on to the Chief Justice? So, for example, I'm familiar with the state of Florida, and the governor of the state of Florida is fighting with Mickey Mouse, basically. And so if the governor, through the Secretary of Education, made it clear that in any public university, anytime a professor says anything positive about Walt Disney, that will be considered an offense.
That would be horrific. However, under this court's holding in Sweezy, that would not be allowed. Because there, this court specifically stated...
Well, no, I mean, Sweezy was decades before Garcetti, right? If we take your position, right, Garcetti says that when you're in the classroom, teaching the class that you've been hired to teach, you are not speaking as a citizen, you are speaking as the government. And so what limiting principle would let you say that what happened here is okay, but it would not be appropriate to have Governor DeSantis say you can't say anything positive about Disney?
I would respectfully disagree with your perception of academic freedom. This court, when it was deciding the case University of Michigan v. Ewing, stated that there are multiple different types of stakeholders in the interest of academic freedom, and that was the government that is understood as the executive and the legislative branch, like Governor DeSantis in this case, in your hypothetical. And then there is the university or the academic institution.
Well, let me change this up then, right? You know, to become a university president in a public university, you got to be pretty politically savvy because you know where your bread is buttered, okay? It's pretty clear that Governor DeSantis does not like Disney. So I'm the president of the University of Florida. Nobody has communicated to me, but I make it clear that it is an offense when you are teaching your classes to say anything positive about Disney. So it's not the executive doing it, the university itself does it. That would be allowed under your view, wouldn't it?
Under the principles that under the principles that has been delineated under Garcetti, yes, that would be allowed. However, the limiting principle here would come externally from this idea of marketplace of ideas that this court has espoused whenever it has held the First Amendment.
So if a college dean really headed in for one political party, they really hates the Green Party, and the dean requires that professors of social studies teach that the Green Party is evil, that there's no First Amendment protection for the professor who disagrees with that, right?
If it were the case that it was within the university's curricular interest in teaching a certain type of class, for example, if that class is related to the environmental law or environmental studies, then there would be an argument to say that there is no, the university or the academic institution would have the plenary right to control the speech of the professor in line with the university's policies.
Is your answer that whoever is properly in control of the curriculum can specify what is taught, even if it's something that has a strong political valence, like the Green Party is evil?
That is correct, Your Honor. Okay. And in addition, what also is a limiting principle would be the employment contract that is given to the professor. In this specific case, the employment contract was only for teaching. It is understood that universities and academic institutions have multiple different roles, and as Professor Robert
do you see how that has a kind of a totalitarian feel about it?
It does, Your Honor. I can see that. However, this is the law, and this court's academic
Well, it's not the law until we say it's the law. That's the question.
That is the law because this court has said it was a law for the multiple decades.
No, we didn't decide that question in Garcetti.
No, Your Honor.
You're asking us to extend it here.
No, Your Honor. But the limiting principle to that would come from the idea of academic marketplace of ideas, because no rational professor would want to teach in a university where the political views were imposed upon them.
Well,
through the operation of the market.
If I need a paycheck, if I've got a child who needs an operation, and I don't have the ability to go without a paycheck for a couple months, I might just suck it up and teach if I'm worried about being disciplined. It's a very chilling effect, isn't it, to put in a policy that says, one of these examples, you can't say anything bad about a particular party.
That is a specific example. However, Your Honor, in most cases, university professors, faculty members, as well as students, have the freedom to choose the institution in which they choose to teach.
We don't usually let the marketplace of ideas justify government restrictions on speech. Can you think of another instance where we've done that?
No, Your Honor. Specifically, however, this court in Sweezy, Keishan, and cases that decided decades after that specifically stated that government intrusion into the academic institutions is not allowed. And that is the protection that the value of academic freedom under the First Amendment jurisprudence does provide.
Why is it the better way to handle this just Pickering? Why is it, there's a lot at stake here. We've got the minds of our young people, our future leaders, and, the ethical implications of canceling a criminal defense attorney for representing a client zealously, that's a matter of great public importance. So why isn't, if the university has some really important reason why they shouldn't be allowed to teach that, fine, we can address that under Pickering. But if we're going to balance all these interests, why do we want to leave the balancing out of the equation?
And that would be because this court specifically stated in Epperson v. Arkansas that courts do not and should not intervene in the resolution of the conflict that arises in the academic setting between the public employer and the individual faculty members because it lacks the expertise.
Well, what if the dispute is really between the faculty and the students? In other words, are the students in effect given a veto over what they have to hear? Is the university in effect empowering the students to say, we don't want to listen to this particular professor's views? And that is one of the reasons he was discharged, right? That the class was, quote, disruptive. What if that's not his fault? What if it's the students?
The students in the employment context, the students' opinions is not dispositive. It is true that the WCC in this case was responding to the students' interests, but that was because of the educational mission and the objective that the WCC had in controlling the speech of its instructors. For example, as noted in pages, I believe, 6 and 7, when Professor Smith was engaged in the philosophy of law course teaching that class, he specifically pointed to a vulnerable-looking individual student to defend the position that he knew that the student disagreed with. And that when that student was unable to do so, he went on to berate that student and say that that student needed to develop a thicker skin. And this created an outrage not only among the student body, but also on the social media, making it unable for WCC to continue its educational mission of teaching the students effectively, in addition to surviving as an institution by retaining the current retention level as well as the student recruitment level, as was stated was the mission of WCC on page 4.
So do you think we should write, if we side with you, should we write this narrowly just to focus on that last part you're talking about, the fact that he picked on a vulnerable student and articulate a different rule for a case where it's just about his choices of what he's going to actually cover in the classroom?
It should be broader than that, Your Honor, because the university has a curricular interest in determining whether or not what is said and how it is said inside of the classroom. And this specific case falls well within that kind of curricular interest that the university or an academic institution has, and WCC was well within its powers to determine whether or not to terminate or to extend an employment contract to an instructor. As Professor Robert Post said—
Excuse me, I thought the retaliation claim wasn't based on the argument that the university punished him because he was mean to the student, but because it disobeyed the administration when they told him to stop using the examples in the next class that he taught, and he disobeyed that. I thought that was the basis for his not being reassigned or not being rehired. Is that not right?
Yes, Your Honor, that is correct. Those two things are closely related because one thing led to the university basically asking the instructor not to use a certain example, as was within their curricular interest. And then Professor Smith, the petitioner, declined to follow the instruction, and therefore his employment contract was declined to be extended.
So being mean and disrespectful to a student, even under your theory, could be a valid basis to discipline? It
depends on the mission and the objective of the university, and as Professor Robert Post in his Yale Law's review article stated, that educational institutions not only serve the role of creation of knowledge, but it has a twin goal of education. And within that education context, Garcetti doctrine should clearly apply in this case because academic freedom, under the academic freedom principle, the curricular interest of the university is paramount. So as I previously stated, because of the academic freedom principle does not extend to individual professors, but rather adheres to protect the individual institutions, this court should affirm the ruling of the 13th Circuit. Thank you.
Thank you.
May I proceed?
Yes.
Honorable Chief Justice, Associate Justices, and may it please the Court. My name is Shakuan Smith, and I also represent the respondent, WCC, and its administrators, Shalia Baird and Albert Hall. As my co-counsel has described, universities enjoy broad discretion in crafting their curriculum, and they also enjoy broad discretion in crafting their institutional policy and identity. Therefore, this court should affirm the judgment of the 13th Circuit Court for two primary reasons. First is that WCC is acting as an employer and not as a sovereign, and therefore it can be allowed to require an employee to speak. And two, the NSC program is a form of government speech, and therefore it can control and regulate the viewpoint and contents of that speech.
Counsel, what if we agree with you on your position, but we disagree with your partner on the other one? What would the remedy be?
In that aspect, since the compelled speech claim is a slightly different claim from the retaliation, then this allows the university to still effectuate its policy in allowing the university and allowing the professor here, in this case, having to speak the policy at bar if he is still retained, but then obviously not allowing the university to. So
the disposition would be to remand the claim for further proceedings on the first claim, but not the second?
That is correct. It will be determined in that manner.
Okay.
Is there any limit to what a public university may compel a professor to say? I mean, let's say a state legislature passes a law that says that every one of our public universities in every class, every professor must begin with a 5-minute script about how a fetus's heartbeat can be detected at a certain number of weeks, and discouraging abortion. Let's say there's an adjunct professor at that university who works for Planned Parenthood. Can you compel that professor to give that speech at the beginning of class?
Your Honor, there will be a slightly different calculus, as my co-counsel has described, in understanding what academic freedom is. So looking at the state legislature necessarily compelling people to speak within the classroom, that would be the government acting there as a sovereign and not necessarily as an employer, versus the relationship between the university and the professor. So in that case, that may not be appropriate, but if it was university and prescribing their own curricular interests or institutional identity, then yes, if it was the university working at the level, it could do so.
So in other words, my colleague's question about Disney, you could compel an affirmative statement. If it was the University of Florida, dean or president could compel a statement in the beginning of every class that says Disney's bad.
It could do so, Your Honor, because as this court noted in Waters versus Churchill, is that when the government is working as an employer, it has plenary power and authorities that it can do in a way that it cannot control necessary citizens as a sovereign. And so to sway.
What about then, why couldn't, under that theory, because we are in the ambit of the First Amendment, and if it's acting as an employer, why couldn't it say at the beginning of each class, you must say the Our Father? I understand there's a different part of the First Amendment, right? But are you saying then that it matters for the freedom of speech whether we decide they're acting as an employer versus a sovereign, but for a different part of the same amendment, it doesn't matter?
No, because a public employee's constitutional rights are not stripped away in entirety. And so if you're saying Our Father as into religious context, that would be an establishment clause issue. So the government in this case cannot run afoul other constitutional rights and values of an individual person.
So that for establishment clause purposes, it doesn't matter whether the government is acting as an employer, but for First Amendment free speech purposes, it does.
Yes, there's a slightly different analysis there.
Why would we adopt a rule that says that in one context whether you're acting as an employer matters, but in the other it doesn't?
Because there, in our case here, what Professor Jonas Smith was asked to recite goes directly to his proper functions as an employee at the university, and they're not compelling him.
Yeah, but that doesn't really go to your. I mean, the point you were making is the university here is acting as an employer, right? Well, why wouldn't a university acting as an employer but talking about a religious message still be acting as an employer?
Because that implicates someone's private interest as a citizen, and so their religion is bound to them outside of their employment context, versus here Professor Jonas Smith's contention derives from his educational as well as academic scholarship directly linked to his job, not necessarily as a private citizen. That would transcend the bounds if we are establishing a certain religious clause or saying within the classroom, which would be more like Barnett, where students were forced to convey the Pledge of Allegiance. And so going on to my second point, when looking at the case at bar, the NSC program is a form of government speech. And as this court has noted, when the government is speaking, the First Amendment does not attach or apply, because as Justice Breyer noted in Boston versus City of Boston versus Shirtlift, the government has the right to espouse and promote a certain policy. Therefore, it can choose the viewpoint and those contents. And so this court looks at 3 factors when evaluating if this is government speech, and that is first control, perception, and then the history. So first, we can evaluate the control here. As the record notes on pages 4 and 7, WCC worked in consultation with the local elected government officials to craft this NSC land use acknowledgement, but then also the civility policies in direct response to some issues going on at the university concerning low retention rates, tension between the faculty and administrators. And so the message that was on the NSC policy was generated by the government from its own crafting.
Could the university here have, the college here, have, as part of their building values, say, you know, we believe patriotism is important, so those of us at WCC believe that you should hear the Pledge of Allegiance, and then required the faculty member to read the Pledge of Allegiance to the class?
If it is part of the institutional policy as a public employer, yes. The students would not be allowed or forced to take the Pledge of Allegiance, but as an employee of the school, then yes, if that is part of their institutional policy, they can do so, because again, they're requiring the professor in their official capacity, not in their private capacity. And that is a slight distinction here that the Sixth Circuit Court noted in Parate versus Issabor, is that when you are compelling a professor to convey something in their personal capacity, then yes, that runs about
what does the word "we" mean then at WCC? We value and our campus values include. Wouldn't that lead the students to think that the professor is the cheerleader for that viewpoint personally?
Well, that would just honestly go to the perception factor, which is one of the other factors that we look at under the government speech doctrine, and that is we as in WCC. So it also says, if you have further questions, please contact the Office of Diversity, not Professor Jonah Smith. And Professor Jonah Smith, as working as a representative of the university, is a part of that we. However, when he is speaking as a private citizen, then he does not have to adopt these beliefs, and the university did not fire him for not failing to adopt those beliefs. They simply fired him for failing to comply with the conditions of his employment contract. And that is what the Sixth Circuit Court held in Johnson-Curry versus Abu-Asi.
Why wouldn't it be a good compromise here when we're trying to vindicate multiple interests, including academic freedom? Why wouldn't it be a good compromise to say that you can require your employee to provide a certain speech, but if he or she wants to include his own personal view, either in a syllabus or in some other classroom context, that they should be allowed to do so? Why shouldn't we kind of land there?
Just going back to my co-counsel's argument, is the universities as the autonomous decision maker to decide what is taught, how it's taught, and who can teach. And as the First Circuit Court noted in Lovelace versus the Southeastern University of Massachusetts, they said that the university can set the curriculum, the homework policy, the grading policy, and their institutional message, and a non-senior professor cannot be made a sovereign unto themselves. That means they cannot dictate what the school is going to, how the school is going to function, and what viewpoint they're going to espouse.
Does it make a difference that he was non-tenured?
It's not dispositive, but however, it goes more to the fact that he will have even less control and say than a tenured professor.
So let me ask a similar question to the Chief Justice. What if we draw the distinction at whether the curriculum is specified? And we say where the curriculum is specified, it's government speech, but where there is a range of freedom for the professor to express his own views, as there would be in these higher level classes, then Pickering applies in that context. Why wouldn't that work?
Pickering should not apply in that context because as the Second Circuit Court noted in Weintraub, we should not leave the province of balancing within the courts. We should leave that with the universities and the administrators who know what the best interests are.
Yeah, but the difference is that where the university has, it's sort of like my public forum example, right? Where the university has a course and invites professors to express their academic views, if the university then punishes a professor for a particular view expressed, it's highly likely that it's viewpoint discrimination that we condemn in other contexts. That's the problem I have with your distinction.
Well, Your Honor, the university, within its ability to craft its own ideology and viewpoints, and so since this—
Right, but that would be true. If the university specifies the curriculum, that's one thing. But my question is, what if it's philosophy of law, and we invite professors to use their professional judgment about what to teach? But then, if we do that, we can't allow the university to punish a professor for a particular viewpoint.
Yes, we can allow them to punish them for a particular viewpoint. However, when we're looking at the pedagogical methods that that a professor is using within the classroom, that is still within the university's jurisdiction, because that goes to how something is taught. And so as the, again, going back to the First Circuit Court in Lovelace, that dealt with the pedagogical view of how something is taught. Then also Martin versus Heatrick out of the Sixth Circuit Court, where there you had an English professor who wanted to use some outlandish examples about her marriage in the Vietnam War. And although that was not uncomfortable for the students, that undermined the university's goal to train the students, because they had an inability to comprehend based on her pedagogical method. But
Pickering would allow the state to adjust those, to balance those considerations, right? I mean, you wouldn't, you're advocating a per se rule that whatever that the government basically wins because it can dictate what the professor says in either context.
Well, the courts is not the province of deciding what is the best educational method or goals. And as the Sixth Circuit Court noted in Evans, Marshall versus the School Board of New York, is that this will lead to the court deciding, in that case, they were having a hypothetical about deciding which vulgar lyrics can be used in the classroom to portray a message, or which type of religion can be used in a classroom. That is not for this court to decide. That is for the universities in their capacity as the people who
Isn't that why the university hired the professor, though? I mean, right? I mean, imagine the course is cultural anthropology, and the dean of the college is a molecular physicist. So you hired the woman, in my hypothetical, to teach cultural anthropology because she's a cultural anthropologist. But why would the molecular biologist know anything more than one of us sitting as a court? That doesn't seem to make a lot of sense.
Because tenured faculty, as well as administrators, as a body, as a governing body, are the autonomous decision makers within our universities. We leave the judiciary outside of those decision-making calls just because there's better expertise left for them. And I also would like to address in a previous discussion that you had with my opposing counsel regarding the creationism versus Darwinism. In that case, there is no distinct difference. Both of these situations call for the university to make a content-based decision, and that is not necessarily compelling that professor in the biology aspect to adopt the beliefs of Darwinism, but when they are employed as a professor, they must teach the Darwinism aspect. And that is the same case here, where Professor Jonah Smith is hired in this particular instance to convey the message of the NSC program. He, again, does not have to affirmatively adopt those beliefs and viewpoints. And so there is no difference because he is not made sovereign unto himself. And also, just going back to my, my opposing counsel on the other side noted in Tinker, is that yes, they did not all shed their constitutional rights at the door. However, this court explicitly stated in Garcetti that a public employee entering into this profession will have to understand there will be some limitations on their constitutional freedoms for the very fact that their employer has key and vital interest in ensuring the efficiency and proper functioning of our government. And if there is a constitutional cause of action for every employment disagreement or every word uttered or every word that is required by their profession, then this court will be bogged down by a litany of litigation and the government will not be able to function. Therefore, we respectfully ask that this court find that they can dictate their own policy and not a professor, and affirm the judgment of the 13th Circuit Court. Thank you.
Thank you. Petitioners have reserved some time for rebuttal. You may proceed.
May it please the court, just a few points on rebuttal. First, the respondents ask this court to view the government as an employer only when it suits them, because under their view, under the free speech clause, they're acting only as an employer. They have their employer cap on, but under the establishment clause, they don't. But when does that change? When does the government decide to put that employer hat back on? Under Garcetti, nothing stops the employer, the college, from making that decision. And second, the court asked, isn't this a little totalitarian? Yes, it is. We have never in the history of this country operated on the assumption that the government has unchecked discretion over our individual freedoms. Garcetti and the government speech doctrine in colleges permits that. WCC could require professors to speak out against Mickey Mouse. And it could require the college to require a social studies teacher to teach that the Green Party is evil. And as the respondent stated, it could require a professor to pledge allegiance to the flag. But
Ms. Skroch, why isn't it a more nuanced and better rule for us to say that where the government specifies the curriculum, it's a Garcetti situation, but where the government permits a course to be taught according to the professor's academic profession based on his or her views, then it's Pickering. What's wrong with that compromise?
Your Honor, because it places this all up to the discretion of the government. Simply, we have never operated on the assumption that curricular interests justify a categorical exclusion of individual freedoms. When we're when we're allowing the college to make those decisions and say when they choose to exercise more control over the classroom, then they have greater authority to do so. But that flips the Bill of Rights.
I think you told us earlier that the government could require that Darwinian evolution be taught in an evolutionary biology class. You drew the distinction as one of not compelling ideology. And when I asked you, well, how do you tell the difference, you said it's sort of fact case by case. Can you define for us what the rule is that you're advocating for how we identify something as ideological versus non-ideological?
Your Honor, again, there's no straight rule, because in ideology, when we're looking at—
So I know it when I see it?
Yes, Your Honor, simply, but that complies with free speech jurisprudence here. When we talk about obscenity, we know it when we see it. Fighting words also.
We usually mock that standard as not very clear.
Your Honor, however, in this case, an ideology, simply the court can't— the college isn't the one who's able to decide that their viewpoint is simply portrayed as a fact, isn't an ideology. When it's the government's viewpoint and against the professor's viewpoint, you cannot require the professor to deliver that viewpoint when they disagree with it. In Woolley versus Maynard, that was the decision. You're not allowed to require individuals to become a mobile billboard for a government message. And the same goes in Barnett. Simply, this case would flip the Bill of Rights on its head and state that individuals only have individual freedoms when the government permits it. But the Bill of Rights reserves freedoms from the government. It's not permitted by the government. We ask this court to reverse. Thank you.
Thank you, counsel. That concludes our argument. I understand that we will leave the bench this time.
All rise.
Everyone, please be seated. Well, wonderful job by all counsel. I mean, we're going to take a couple minutes each and provide some feedback. Why don't we start with my colleague to the far left, and everyone, before you give feedback, just let these folks know who we all are, and just a couple minutes of feedback each.
So my name is Michael Allen. I'm a federal judge. I sit on the United States Court of Appeals for Veterans Claims. So I have been on the court for about 5.5 years or so. And before that, I spent 16 years as a law professor, and for almost all of those years, coached teams in the ABA NAAC competition. So it's interesting to be on the other side of the bench. I will tell you that, you know, it would be a pleasure to have any and all of you appear before me in my day job across the street. You know, I'm not going to be very specific on each of you because I know I used to tell the students that I coached that at this point in time you need to look very attentive but then be singing your favorite song in your ears, right? Because especially now that the competition is over, you'll never argue this again. But you were all very respectful. You knew what the law was. You tried to use the hypotheticals that we gave to not only answer what we did, but then come back. Both sides did this, come back when your opportunity to know what the judges are talking about. You were helpful to the court, right? Because the one thing you want to remember is that in a real case, and we all sort of think about this as a real case in a sense, somebody would then have to go write an opinion that would then govern whatever area we're in, whether it's a state or an area of the law. And so being able to help the judges, being able to then reach a conclusion is very important. So excellent job.
Hi, I'm Stuart Raphael. I am a judge on the Court of Appeals of Virginia. I'm a pretty new judge. I've been there about a year and a half. I did appellate litigation for 32 years before that. So I've been where you're sitting, much more of my career than on this side. And I echo what my colleague said. You all are terrific. You would be in the top, 5% of the advocates that we see in our court. We'd be happy for you to appear in our court. I thought you did Ms. Skroch, you did a great job in your rebuttal of bringing points in that had been argued earlier. Mr. Smith, you did the same thing, going to the creationism, evolutionary biology example. It's really good to be listening to what is happening when your colleagues are up there being asked questions, and then try to incorporate it into your argument. I thought this was a good problem because it was not totally lopsided. I think I see this continuum, and you probably could tell from my questions where I was in my own thinking, but Ms. Skroch, you had the hardest, I think, part of the argument, trying to defend applying Pickering to a compelled speech in the case where the school wants to specify the curriculum. So, Mr. Smith, I think you had the easiest of that, and the two folks in the middle really is where that's for me. That was really the hard issue. Which way does it come out? Do we apply Pickering or do we apply Garcetti? So I thought it was good that the problem wasn't so lopsided, but you all were terrific. I really applaud your work, and it shows that you are here in the final round.
I agree with everything my two colleagues have said so far. My name is Jonathan Biran. I'm a justice on the Supreme Court of Maryland. I've been on that court since 2019. Before that, I was in private practice for a number of years, and before that, the bulk of my career, I was an assistant U.S. attorney, and I was the appellate chief at the U.S. Attorney's Office for the District of Maryland. I really thought all four of you did a great job with quite a hot bench, with a lot of questions just being thrown at you, and it just didn't seem to faze you all at all. And that's hard. It's hard to hold up under that type of questioning, and I thought you all really did so. Judge Raphael took exactly my specific comment, so I'm kind of mad at him for that. but I agree with what he said. But no, I think it's in real life, I think in a case like this, some judges are going to be really looking for a middle ground. And so you need to be ready to fall back on a middle ground that you can live with. And perhaps embrace that if it seems appropriate. Of course, you'd like to have the whole loaf if you can get it, and it's hard to know when to concede, or at least even signal concession. But I think you'll find in your careers, if you're arguing a tough case, you're going to want to stake out that alternative position that you could live with. But great job, everybody.
Great. You just stole my comment. I'm Dan Ortiz. I sit on the Court of Appeals of Virginia with Judge Raphael. Before that, I was a trial court judge for about 7 years. and then private practice before that. So I thought everyone did an excellent job. You handled the questions really well. You also handled sometimes comments from the bench really well. Sometimes judges just make statements and they sort of throw a question at the end of it sometimes. And you turned that into a response on a couple times. So I thought you did a great job. I love the comment that my colleague here to the left, the Chief, just made about finding that middle ground. This is that sort of case, and both sides were dug in on their sides. And I think in real life, you would have been pushed pretty hard to come up with something in the middle ground. And we pushed you pretty hard, and you did a good job sort of standing your ground. So it was a good argument. Thank you.
I'm Eric Brugink. I'm on the United States Court of Federal Claims. I've been there for a long time, 37 years at this point. Before that, I was at the Appeals Council at the Merit Systems Protection Board. Before that, in private practice. I have nothing remotely like a critical comment for anybody. I was very impressed. No practice tips that you all haven't absorbed, as best I can tell. I'm a trial judge, and the only comment I would make is, as judges, we really want to try to find the right answer, and so if we sense any attempt to kind of dodge the question or not confront unhappy facts, we sort of tune out your response. I didn't sense a whole lot of that. I mean, both of you had very difficult arguments to make, and I'm not sure I agree that this thing is susceptible to sort of a middle ground. I think you do, almost by definition, as the respondents have to dig in your heels and say there is no middle ground. But it's true that judges, by nature, want to sort of look for some happy medium and make everybody a little happier. But what I'm looking for is I want to engage with you folks when you're up there discussing your case. I want to know that you're trying to respond to my questions, even if it's something that you have to concede a point. But y'all are terrific. You'll do well.
Well, congratulations to all of you for having made this final round. We don't know who the winner is. We each made a choice and voted, but we have no idea. But I'll just say that I think, in my view, it was very, very close. And all of you deserve to be really proud, and your coaches deserve to really be very proud. So congratulations.
Yep.
Thank you.